A medical power of attorney is a document where you name someone to be able to make medical decisions for you if you're unable to communicate your medical wishes yourself. So really, any adult over the age of 18 should have a medical power of attorney. This document has different names in different states, but ultimately it's there to allow someone to make medical decisions, admission to the hospital, treatment decisions, picking physicians, hospice, long-term care. All of this can be covered under a medical power of attorney. One of the important pieces of a medical power of attorney is for you to spell out what your wishes are at end of life. If there was no hope of recovery, would you want the person acting for you under the medical power of attorney to have the authority to end extraordinary measures to keep you alive? Those could include tube feeding, hydration, it could include restarting your heart if it were to stop, even signing a do not resuscitate order. What's important is that a properly drafted medical power of attorney allows you to spell out what your wishes are and to clearly give a person authority to enforce those wishes at the end of your life. This is why a medical power of attorney is so important for all of us to have. Today in the United States, we have a law called Hipaa, the Health Insurance Portability and Accountability Act. One of the things that Hipaa provides is that doctors and hospitals can't share your medical information with anyone, including your spouse, unless you've given them specific authority to do so. One of the things that a properly drafted medical power of attorney can include is a Hipaa medical privacy release. What this does, it allows the doctors to share information with whoever you've named to act as your medical power of attorney. This is very important because if they don't have that release, the person you've named may have difficulty getting access to information that they're going to need to make informed decisions regarding your care. Many people who have medical powers of attorney don't realize that if they were drafted and executed prior to 2004, they don't have that Hipaa medical privacy release language, and so need to be updated. College-age children also need medical powers of attorney. Many of my clients who have children who are away at college or over the age of 18, if they were to get sick, injured, be in an accident, parents can be locked out from any medical information about their child. So one of the things that we recommend to all of our clients who have children between the ages of 18 and 25 and are still kind of connected to the household, that medical power of attorney should be signed authorizing the parents to be able to make medical decisions if the child were to get sick or be in an accident. There's nothing worse than a parent who hears that their child who's away at college is injured or has gotten sick, they're in the hospital, they call the school to get information and are not allowed to get any information because of those Hipaa regulations. Therefore, before you send that child off to school, make sure they execute a medical power of attorney.